Nice. Good afternoon. Senate Committee on... Oh, yes, ma'am. And as we began, before we call to order, I'll just make the obvious announcement that there are two committees meeting. Members are on both committees, both important matters being discussed, so we'll be back and forth in and out. And with that, the Senate Committee on State Affairs come to order. Will the clerk call the roll?
Campbell? Here. Hall? Lucio? Nelson? Here. Powell? Schwartner?
Present.
Zaffarini? Present. Birdwell?
Present.
Hughes?
Here.
The quorum is present.
Quorum is present. Thanks, Andrew. And glad everyone's here. It's been a busy couple of days already in the special session, first called session of the 87th legislature. And looking forward to hearing some important stuff today. It's officially called the first. That doesn't necessarily imply much, but it probably does. So we have Senate Bill 5 and Senate Bill 24 on the agenda for today. The first one is Senate Bill 5. Of course, both of these deal with social media, and since I'm the author of Senate Bill 5, in a moment I'll yield the gavel to our vice chair to handle the proceedings. Any member have any remarks or questions or comments need to be made as we get underway? Very well. Oh, thank you, Taryn. Thank you so much. We thank the members of the public, the real people, for being here, and we thank especially our talented committee and member staff, and I thank the members. And so with that, I'll yield the gavel to our vice chair to get underway. Mr. Chairman.
Madam Clerk, I don't have data fields here. Okay. All right. There we go. All right. Chair lays out Senate Bill 5. Recognizes Senator Hughes, the author, to explain the bill.
Thank you, Mr. Chairman, and thank you, members. In 2017, not that long ago, Justice Kennedy, in an opinion he wrote, was joined by several of the court's more liberal justices at the time, talked about social media as, quote, the modern public square, unquote. He acknowledged that these few dominant websites, quote, for many are the principal sources for knowing current events, checking ads for employment, speaking and listening. Perhaps the most powerful mechanisms available to a private citizen to make his or her voice heard, unquote. We all realize that intuitively. We all realize that from our own experience and the experiences of our constituents. We know that today a very small handful of social media sites are able to drive the national narrative. They have massive influence over the progress and development of medicine, of science, social justice, election outcomes, and public thought writ large. That's the reality of where we are. It's important to note that this doesn't just harm conservatives. Our mode of government relies on good faith exchange of ideas, and when much of the public conversation is muted, we know that both sides, all sides, suffer from that. In fact, if this trend were to continue, we'll end up with a conservative internet and a liberal internet, and Americans on each side only become more angry as they hear only from like-minded voices, more frustrated, more angry, more divided. Senate Bill 5 addresses this concern. It has two parts. The first part of the bill demands some transparency from the social media platforms. To bring transparency, it requires a platform to publicly disclose on an accessible website how they select the content users see and what sort of contents they allow. It also requires a platform to implement an easily accessible complaint procedure for users to submit a complaint regarding illegal content or the platform's removal of allegedly harmful or offensive conduct. The bill would also require the platform to investigate any report of illegal conduct within 24 hours. So when you see illegal conduct on a platform and report it, they've got to act. So this is about making sure that it's being handled responsibly. And also allow a user whose content's been removed to file a complaint and receive feedback and a review of that removal condition. Perhaps one of the most frustrating experiences for Americans from the left and the right when they are handled this way by social media. They're blocked, or a post is blocked, or they're deplatformed, or they're demonetized, or any of those new terms. When that happens, there's no one to talk to. What do you do? How do you find out why they did it, and what's my recourse? No one knows. That's wrong. There should be a recourse for for users. The bill also includes legislative finding that these biggest social media sites are acting as common carriers. Justice Thomas has written about this extensively, and he's not the first one. It's an understood concept we'll talk about as we go through, but they are common carriers of public speech for all intents and purposes. The bill then draws a critical distinction between censorship based on content versus censoring viewpoint. Of course, we understand these sites need to be able to moderate content. Violent, overtly sexual posts, that sort of material is one thing, but they cannot deny your participation based on your viewpoint, including your political preferences or your religion. How is it like a common carrier? Some conservatives will say, and not just conservatives, well, these are private companies. They can do what they want to, go somewhere else. But we understand the concept of a common carrier. What if your cell phone company said, we're going to deny you service because of your religion? No, we don't allow that in America because they're common carriers. They enter into this business and have significant market share. What if your cable TV provider says, yeah, because of your religion, we're not going to give you service. We're going to cut you off because of that? No way. We don't do that in America. There are appropriate guardrails, and that's what we're looking at here. So the second part of the bill allows people who've been censored to get back online, again, to handle that frustration that people deal with. Under this bill, a social media site in the file bill with over 65 million monthly users is covered by the bill, and the committee sub is going to adjust that number slightly. We'll talk about it in a moment. But those sites are prohibited from censoring a person or the content that person posts based on their viewpoint or on the viewpoint expressed in the post. If the site does block or restrict a user based on viewpoint, that user can file suit against the site to get back online, and the site has to pay their attorney's fees. If the user can't find a private lawyer or doesn't wish to go that route, the Attorney General's office can bring suit on behalf of a user or group of users. Now, sometimes folks who follow this closely have asked about Section 230. That's the federal statute, Section 230 of the Communications Decency Act, which gives great protection to social media companies and limits what states can do. To be precise, under federal law, social media sites are expressly protected from liability for certain content moderation decisions. Section 230 prohibits the following: holding websites liable for restricting, quote, access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. Section 230 also prevents us from treating websites as the publisher or speaker of any information provided by another information content provider. Most of the analysis, at least the shooting from the hip analysis of Section 230 that we hear from platforms and we read in the traditional media, stop there. But Section 230 goes on. It says states are expressly allowed to regulate websites so long as those regulations are consistent with federal law. Senate Bill 5 before you complies with Section 230 liability protections because it does not impose liability for content moderation practices. It simply enforces a prohibition on viewpoint-based censorship. If the social media site refuses to put the user back online, the court can issue an injunction ordering them to and hold them in contempt if they fail to comply. We do have a committee substitute.
Members, Senator Hughes sends up committee substitute, Senate Bill 5. Chair recognizes Senator Hughes to explain the differences between the base bill and the committee substitute.
Thank you, Mr. Chairman. Members, the committee substitute is similar to the bill that was filed, and I should have said the filed bill should look familiar to you because this bill in an almost identical form was passed by the Texas Senate, got a little slowed down over in the House in the regular session. That was Senate Bill 12, and so we're back. So here's what the committee substitute does. It adds to the legislative findings that social media platforms with the largest number of users are common carriers, in part by virtue of their market dominance. It also changes the application of the bill from 65 million domestic active users to 50 million domestic active users. It provides that a user cannot waive any of the protections provided in this bill. As you know, from time to time, a commercial entity with great bargaining power will say to a smaller party, here's our contract, take it or leave it. And in the contract it says, by the way, by signing our contract, you're waiving all your rights under Texas law. They can't do that. They can't do that, and this bill makes that clear. It also expands the severability clause. As you know, many times statutes are challenged, and it makes it clear that only the challenged portion of the statute will be affected by a court challenge, not the entire statute. There will be some discussion today, I know, from both sides, I suspect, about the Florida bill and the Florida ruling. We're going to have some expert testimony on that, again, from both sides. The Florida bill was significantly different from the Texas bill, and even the Florida bill. You may have read it was struck down. That's not the case. Part of the Florida bill has been stopped from enforcement, but the private lawsuits in the Florida bill, those are available today, ready for anyone to file. Now, that case is going to go to the appellate court and the Supreme Court if this one doesn't get there first, so stay tuned. But this is different from the Florida bill. This bill is not, we're not concerned in the least about that Florida opinion when we look at this bill. And even that Florida opinion limited part of the bill, not the whole bill. Thank you for your indulgence for this extended layout, and I will yield for your questions.
Members, questions for Senator Hughes? Senator Campbell and then Senator Zaffarini.
Thank you, Mr. Chairman. Thank you so much, Senator Hughes, for bringing this forward. I want to ask, so the fallback for someone who can't file suit themselves for whatever reason is Attorney General. But does anything compel Attorney General to actually take up the case? Otherwise, it's falling on deaf ears.
Senator, that's a good question. So right now, if this bill becomes law, when this bill becomes law, any Texan can bring a suit. And under the bill, the social media company will be required to pay the attorney's fees from that user who wins the case. So that should make it easier to find an attorney. Most of us couldn't afford to pay an attorney by the hour to bring that suit. So attorneys will know if they win, they're going to get their attorney's fee. So that helps us find a private lawyer. But yes, for those folks who don't want to go that route, there'll be a process with the Attorney General's office to bring this report. Now, you're right, they do have discretion whether to take the case or not. But this bill's pretty clear. If a social media company violates this, violates your First Amendment rights, they've got to put you back online.
And a follow-up, just a little different, but the Attorney General has enjoined with some other states, correct, to take on Google and some others. I don't know the details of that. How does what's going on there affect, does that interact with this bill?
Well, that's a good question. Texas is leading a number of other states in litigation against Google. I think, haven't looked carefully at the case, I'm not involved in it, but I believe it's an antitrust case.
Yeah.
It has to do with how they use their market power and abuse their market power, and also about transparency. And many people are watching that case closely because the discovery process, once they've got to open up the books and let us peer into the keyhole and see what they're really doing, it's going to be very interesting. So it's not directly related to this case, but I wouldn't be surprised if some of the discovery in that case didn't yield interesting information about viewpoint discrimination.
Thank you, Mr. Chairman. Mr. Chairman.
Thank you, Senator.
Before I go to Senator Zaffarini, Madam Clerk, please recognize that Senator Hall has joined us. Senator Zaffarini, you're recognized.
Thank you, Mr. Chairman. Chairman Hughes, did you highlight, I missed it if you did you highlight the differences between Senate Bill 5 and the bill that we considered during regular session?
Senator, I don't know if I did. I think I made the generalization that they are very similar, and the difference would be the number of users. Senate Bill 12 that we had during the regular session, it applied to those companies with 100 million global users. The bill before you and the committee substitute focus instead on domestic users. There are some social media companies that are big worldwide, not as big in Texas. So we want to focus on those that have the biggest footprint in Texas. And beyond that, did we make any changes from the Senate Bill 12? Beyond that, the file version in the committee sub are Senate Bill 12 from the regular session.
Thank you.
Thank you for
That's
asking.
on page 10 of the committee substitute, where you define the number of users. I believe that's where I just said, yes, line 15,
Yes, ma'am.
where you refer to the 50 million active users. So what companies would be covered under this particular provision?
So, of course, these numbers change as companies come and go and as companies grow. But as we understand it, the primary ones affected would be Facebook, Twitter. Google is the company behind YouTube, and so they would be affected as well. Again, with these, this is a catchment area that companies could move in and out of, but those are the ones that we're aware of based on the numbers today.
Texas always takes pride in our reputation as being so pro-business.
Yes, ma'am.
And yet we are defining all of these restrictions and prohibitions and requirements and quarterly reports, et cetera, of this particular business. Is there any danger that this would be considered anti this kind of business?
No, thank you, Senator. I bet we'll hear that. I bet we'll hear that, and it's a good discussion to have. Again, just like a cell phone company cannot deny you service based on your religion, or a cable company based on your politics, these companies are common carriers. They've chosen to enter into this business. They have captured tremendous market share that would make John D. Rockefeller blush, and they have such power by virtue of that that it's appropriate for us to require this of them.
Thank you, Mr. Chairman.
Thank you, Senator.
Thank you.
Madam Clerk, if you would, please recognize Senator Lucio has joined us. Members, other questions for the author before I ask a couple of questions? All right. Mr. Chairman, you had mentioned Florida case, Florida bill. Do you know what portion of the Florida law was, what's the legal term?
Enjoined.
Enjoined.
Sir.
Had injunction upon it. Is that same element in this bill?
Senator, it's not, and we do have a witness who's going to give us a thorough discussion of the Florida bill. Not to defer your question, but
No,
to
that's
defer
okay.
your question.
If you tell me which witness that is, I'll ask him those questions.
It's going to be when Mr. McCullough comes up.
Mr. McCullough, okay.
It'll be in his direct testimony. I was going to ask him,
Okay.
and I'd urge
Okay,
you
then
to as well.
I'll defer to you. Because I know that, look, a lot of decisions get made at the district level, but until, I think Florida's in the 11th Judicial Appellate Region, federal, out of Atlanta. I don't think it's gotten to them yet, but with that, I'll defer to Mr. McCullough when he arrives to either hear your questions of him for greater granularity.
Thank you, Senator.
With that, members, any other
I
questions?
would say that the Florida bill exempted Disney World. Ours does not. That's one big distinction between the two. And I don't blame them. That's a big deal in Florida, but ours doesn't talk about Disney World.
Okay, all right.
Fiesta, Texas is not implicated directly with this bill.
Yeah. The state of Texas is already its own, little wonderful world. So, yes, sir. Hoo-ah. All right. Members, we're going to move to invited testimony. I do have one individual for invited testimony. Invited testimony will receive 5 minutes. Chair calls Joshua Trevino. Joshua, if you would, please join us. State your name, whom you represent. You'll have 5 minutes. I'm sure you're very familiar, but when the yellow light comes on, that means you have 1 minute remaining, and at the red light, please conclude your testimony.
Yes, sir.
With that, Mr. Trevino, please state your name, whom you represent, and your
Yes, sir. Joshua Trevino from the Texas Public Policy Foundation. Thank you for the opportunity to testify on SB 5 in this special session. I'm the Chief Innovation Officer at the Texas Public Policy Foundation, and in this role, I look to the future of Texas and policymaking with the aim of preparing our state for the challenges to come and preserving the inheritance of liberty that has characterized us as a nation since 1836. SB 5 is a necessary act for securing that future and that inheritance. It exists as a reaction to the overreach and excess of social media firms that have taken it upon themselves to police the public square and stifle ideas and beliefs that they disagree with, ideas that are frequently held by broad swaths of the American public, both left and right. Did they do so from a standpoint of exceptional power within our civic space, undergirded by a special favor granted to them and to no other form of media by federal legislation, exemption from liability for user-generated content? Unfortunately, what we see time and again is these firms' unfitness to competently or consistently exercise that power. Individual citizens with unorthodox opinions are deplatformed, and then the orthodoxy shifts. Democratically elected representatives are shut down, while dictatorial regimes communicate without hindrance. The state of Texas cannot afford to allow this status quo to persist. The fundamental question in social media policy now is simple. Who rules? If an unaccountable corporate elite is in charge to the point of de facto setting the terms of engagement in the public square, then our experiment as a republic is over. But the foundation does not believe it is over. The people still rule, and our elected representatives still work on their behalf. Therefore, the Texas legislature has both an obligation and the power to see to it that these firms operate in a transparent fashion, accountable if need be, to the Attorney General of Texas. To that end, Senate Bill 5 moves Texas in the right direction by compelling social media firms to publish clear and transparent terms of service, by compelling them to report on their administration of those terms, and by rendering them accountable to the Attorney General to investigate and enforce proper application of that administration. SB 5 holds these firms to account by their own standards. The remedy for social media favoritism and censorship is not an opposite measure of the same. It is equality and transparency of treatment. SB 5 does that job. Thank you to the committee for the opportunity to testify.
Thank you. Thank you to Mr. Trevino. Members, questions of our invited witness? Let me go to Senator Zaffarini and then Senator Hughes. Senator Zaffarini, you're recognized.
Thank you, sir. Your written testimony in the section titled End Corporate Welfare. I'm reading.
Yes, the handout, which I do not have in front of me, but yes, ma'am, please.
It reads, Texas should remove all tax break and subsidies that these companies receive. In addition, reducing state and local taxes and regulations will promote opportunities for increased competition that will help eliminate the potential harmful behavior by these companies at the expense of taxpayers. Again, I go back to Texas has been so pro-business, and yet this kind of business seems to be singled out. Why would you single out this kind of business and not make that statement for others? Or do you make that kind of statement for other types of businesses?
Yes, Senator. So when you asked that question initially, I think that's the key question before us, because we have to strike a balance between what our primary goal is, which is the liberty and sovereignty of the people of Texas, in this case, counterbalanced against the need to have a vibrant and market-based economy in Texas. And so in this particular case, it's the estimation of the foundation, in full candor, that the power and the activity of these particular firms, which, by the way, is again, I can't stress enough, undergirded by a special favor granted to them by the federal government under Section 230, constitutes a threat to that liberty and sovereignty. So we fully share your sentiment and the sentiment of all those who want Texas to be a free market state. But at the same time, we recognize from a prudential standpoint the need for these firms in particular, given the power they exercise in the public square, to come under this kind of legislative oversight.
Wouldn't removing Section 230 require federal action, not state?
Yes, ma'am, that's correct.
Thank you. Thank you, sir. Thank you, Mr. Chair.
Thank you, Senator Zaffarini. Senator Hughes, you're recognized.
Thank you, Mr. Chairman. Mr. Reno, thank you for your testimony, for your research on this, and for the perspective that you bring. We know the Texas Public Policy Foundation is respected not just in Texas, but nationwide, and for the thoughtful work you do. And so we're thankful to have you here.
Thank you, Senator.
I want to ask you about the potential harm if action is not taken and this kind of viewpoint-based discrimination is allowed to continue. What do you see as the harm from that?
To speculate as to what comes next if nothing is done, is that accurate, sir?
Yes.
Look, the amount of content that goes through these firms is so tremendous that my suspicion is that they will turn increasingly to algorithmic content moderation. So it'll be a combination of unaccountable algorithmic content moderation and then probably politically / socially motivated content moderation is likely what you'll see. Both of these have significant shortcomings. We know about the political and social motivated shortcomings. The algorithmic side is interesting, and it represents a kind of an under-recognized danger. Researchers like Dr. Timnit Gebru, formerly of Google, who, by the way, politically I probably agree with nothing on, but I think she's right about one thing, is that the data sets that are used for algorithmic moderation are insufficient for the job. And so what she and a lot of individuals in Silicon Valley right now are concerned about is particular racial disparities with those data sets. But you can see kind of these comical outcomes that are already arising from a lot of these social media firms. There's one example in August 2019 when Twitter, almost certainly due to an algorithmic moderation mechanism that they had, actually suspended the Mitch McConnell re-election Twitter account. Now, I recognize that some individuals may think that a positive outcome. But whatever side you're on, the interesting thing was that the grounds for the suspension was that the Twitter account had publicized threats against the then Senate Majority Leader as by way of showing what he was facing. And so, of course, the algorithm flipped on, and it was banned. If we don't act, I say we as the people of Texas, the legislature of Texas, don't act, then what we're going to see is much more of this. And it's not going to be done any more competently or consistently than it has been done hitherto.
Thank you for that. I want to ask you something else along those lines. You mentioned this in your testimony. Many times we hear folks talk about bias against conservatives, but you've also heard, I'm sure as we have, Senator Elizabeth Warren from the left criticize big tech giants for the same conduct. The President of the United States, the current president's made comments, and the previous president from the left and the right.
Sure.
Talk to us about that. This is not just about conservative bias, liberal bias. Talk about that, just about limiting free speech, no matter from whence it comes.
You know, one of the big voices bringing up the potential abuse of social media actually was the current Vice President Kamala Harris. Used to talk about that back when she was Senator Kamala Harris, and it's entirely correct. This is not an issue that falls cleanly on left-right lines, nor along partisan lines. Everybody has an interest in equality of access to the public square, and that's what we advocate.
Thank you. Thank you, Mr. Chairman.
Okay. Senator Lucio, you're recognized.
Thank you, and I apologize for my tardiness. Got stopped by the press on the way in. You mentioned politically, you mentioned the word 2-3 times, yet the bill, as my staff and I have looked at, does not mention political or religious speech. What's your take on that?
As long as there is, our take on it, thank you for the question, Senator. Our take on it is that as long as there is equality and transparency of treatment, then that is the standard that we hope is met. And so, you know, whatever it is, if there is iniquitous treatment along those lines, that's something that we hope to stop. But we think that SB 5 does a good job, creditable job of ensuring that equity of treatment.
I'll ask the author the same question. Why, you know, the bill does not contain anything as such. My question is, and I think you heard it,
Well, I did. No, thank you, Senator.
political and religious speech.
That's a good question. So the bill speaks to viewpoint discrimination. And one of the benefits we have in this area,
We do have viewpoints politically and also.
we do. So viewpoints covers politics, religion, healthcare. And I would say this, one of the benefits we have when we legislate in this area, we have decades, I should say, over a century of jurisprudence on First Amendment, on free speech, on protected speech. And so all that applies in this context. So viewpoint discrimination is the broad category that we would use to describe religious, political, that sort of thing.
Okay. Okay, thank you.
Thank you, Senator.
Okay. Members, any other questions? Let me ask one, if I may, Mr. Trevino. As this bill may culminate, as I've seen other folks that have a problem with Silicon Valley, or maybe not Silicon Valley, but the network operators of these social media sites, when you've been deplatformed, to get reinstated is almost like mailing a letter to Santa Claus and hoping you get an answer.
Sure.
What's the mechanism by which if the bill becomes law, and then an individual wishes to seek counsel, what's the mechanism by which you get a response, whether it's appearing in court or an opportunity to rectify the problem before going to court?
Yes,
That
sir.
seems almost an impossibility. Can you tell the committee what that mechanism looks like?
Yes, Senator, I can within the bounds of my understanding, and I want to assure my 7-year-old who is watching this live stream that writing to Santa
I'm
Claus
sorry I
works.
ruined your 7-year, you know.
My understanding, and of course we have the bill author here, so I will defer to him. But my understanding is that the remedy is in the state oversight, and so if there is a deplatforming, if there is an unjust, and I stress an unjust and actionable termination of speech on one of these platforms, that there is grounds for litigation, and so whatever process that would take, either via the Office of the Attorney General or through ordinary civil litigation, then that would be the restorative process. But again, I defer to the bill author on whether I've got that correct.
Yeah, because it just, some of the things that I've seen in national media when, here's an example of an egregious deplatforming, whatever the algorithm may be, and the ability to rectify it seems nearly impossible.
That is concurrent with our understanding as well, and what we've seen in cases where individuals have been deplatformed, seemingly. So sometimes there are cases where you can tell why it happened, but in others, there doesn't seem to be a lot of accountability for the firms.
It's almost as the only way it gets fixed is if you get enough national media attention to the egregiousness of the deplatforming.
Yes, sir.
And then out of some sense of shame, the company replatforms you. But, you know, if you're not the former president of the United States, you're not going to get that kind of media attention.
Yes, sir.
to get
That's
it
exactly right.
I wanted to have a sense of how does this, you know, we're giving a tool available to people to rectify the situation, but in practicality, does this afford them that that ability?
I think there's, yes, Senator, I think one of the things that SB 5 gets right is that it does offer that unique pathway that does not, by my understanding, appear to really exist anywhere else. And so Texans using these platforms would have an option that others do not, which is positive.
Okay.
Yes,
All
sir.
right. Thank you. Members, any other questions? Senator Nelson, you were reaching for your, oh, okay. I thought you were reaching for your light. I'm sorry. Senator Hughes, you're recognized.
Chairman, by way of question and response and on the matter you raised, to amplify what the witness said, he's exactly right. And so the first part of the bill puts certain duties about transparency. What's the process you use to determine what you're going to block, what you're going to let me see, and then it does also require them to have their own complaint process so that if you are deplatformed, blocked, you can go in their system and make a complaint. That's not today. That's pretty hard to do. And you know, maybe if you happen to know somebody at Facebook, or maybe you go over to here in Austin and knock on the door. I don't know. Most folks can't do that. I'm not sure if that would. I'm not recommending you go to the office and knock on the door. I'm not suggesting that. But the bill does clearly say, though, after all those procedures, I'm on page 8 of the bill. Subchapter D, enforcement, action by Attorney General. The Attorney General may bring an action against a social media platform to enjoin a violation of this chapter. And so that's on that transparency portion where they've got to tell you what they're doing and how they're doing it and make sure they're not mistreating you. Now, that's the first part of the bill. The second part of the bill, which is the one that gives any person who has been discriminated against in that way, gives them the right to go to court. That's a separate remedy. But before you get to that, you can go on the front side through that process. So there should be practical steps that any Texan can take when they've been censored under this bill.
Okay. All right. Members, any other questions? All right. Thank you for joining us today, Mr. Trevino. Thank you, sir.
Thank the committee.
We will move to public testimony. And while I know the individual I'm about to call, Steve Del Bianco, Steve is also the only individual witness that lives out of state. And knowing what he's probably going to have to fly back to Dulles. So from a time perspective, members, if I may, while he's down the list, I'd like to invite Mr. Del Bianco to join us for his testimony. And then on deck will be Tom Glass. Oh, I'm sorry, wait a minute. Scott McCullough. I'm sorry. Scott McCullough is on deck. Steve, out of travel schedule respect and the like, I wanted to afford you that opportunity. Members, we're in public testimony. You have 2 minutes to provide your testimony. When the yellow light comes on, you'll have a minute, and then when the red light comes on, please conclude your thoughts. And with that, Steve, you're recognized.
Thank you, Mr. Chairman. I'm Steve Del Bianco, and I'm a lifelong conservative, a former tech entrepreneur, and the founder of NetChoice, leading tech trade association whose members include Amazon, Facebook, Google, and Twitter, and about 35 others. When I testified before your committee in March in the big Senate chamber on the prior version, SB 12, I explained why I thought the bill was a bad move for conservatives, and I also told you that it would be overturned by a court. Well, sure enough, on June 30th, a federal court granted NetChoice's injunction in Florida on a very similar bill to SB 5. Let me quote from the ruling. First, the state has asserted that it is on the side of the First Amendment and the plaintiffs are not. It is perhaps a nice soundbite, but the assertion is wholly at odds with accepted constitutional principles. The First Amendment says, quote, Congress shall make no law abridging the freedom of speech or of the press. And the 14th Amendment extended that prohibition to state and local governments, unquote. The federal court in Florida went on to enjoin all of the content moderation provisions in Florida's law. They left aside an antitrust provision, but they enjoined every word of the content moderation. Now, my written testimony lists 10 First Amendment factors from the Florida ruling that map exactly to SB 5. They map exactly. So SB 5 will similarly be enjoined and we would be forced to sue, as we did in Florida. And then what? All you'll have done is to encourage my members to continue to moderate at will, since you'll have helped to clarify that the First Amendment prohibits you from forcing Facebook, Twitter, YouTube to carry content they don't want to carry. I wanted to bring this to your attention. Just last week, former President Trump filed class action lawsuits against Facebook, Twitter, and YouTube, 3 of them. He asserts that those 3 companies are actually state actors, not private businesses, and therefore they are subject to First Amendment restrictions, and that would be remarkable. Mr. Trump also, in his lawsuit, asks the court to set aside Section 230, find it unconstitutional, and extinguish the law. So I would close, Mr. Chairman, by saying we disagree on whether SB 5 is good policy. But on politics, I'd like to give you a couple reasons it makes sense to stand down at this time. First, let Florida's legal battle continue. It's going to pave the way all the way to the Supreme Court. That's my lawsuit. You therefore avoid Florida's fate in court. Do you really want to hand my industry another victory this summer in Texas? If you stand down and allow Mr. Trump's lawsuits to test your theory on common carrier, he's going to carry that all the way to the Supreme Court as well. And finally, stand down because if SB 5 were enacted and enforced, you would likely be blamed for some of the awful but lawful content that will show up on Facebook, Twitter, and YouTube. And meanwhile, there is plenty of choice of alternate social media platforms other than Facebook, Twitter, and YouTube. So I would look forward to your questions.
Members, questions for Steve or Mr. Del Bianco, if I may. Members, questions? Senator Zaffirini, you're recognized.
Thank you, sir. Thank you for being with us. Is it your opinion that if this Senate bill passes, that social media platforms would not be able to block content that includes bullying and references about Nazism, all kinds of intimidation and harassment?
Thank you, Senator. The First Amendment protects all the things you just said: harassment, anti-Semitism, ethnic slurs, pornography. All of those are permitted under the First Amendment. So if you're held to a First Amendment standard, you can't get in the way of any of that content. So those companies, if they continue to try to regulate speech to keep advertisers and users happy, could find themselves being sued or being pursued in an enforcement action by the Texas Attorney General. And this is why the judge in the 31-page opinion just quickly set aside all of that under a strict or intermediate scrutiny under the First Amendment.
Thank you. Based on your experience in Florida, is there anything that you have learned in that experience that would allow us to amend this bill to make it more acceptable or perhaps even acceptable to you?
In our testimony, we laid out the 10 First Amendment factors that the judge laid out in Florida, and SB 5 has every one of the 10 fatal flaws. SB 12 is not savable on a First Amendment grounds. No one in this chamber believes you could tell the Austin American-Statesman that you must carry Senator Hughes's op-ed. You know that the First Amendment would never let you force them to carry an op-ed. So I don't understand how you believe that this chamber could force Twitter, YouTube, and Facebook to carry content that they don't want to carry. There's been a fundamental misunderstanding of the First Amendment, and I was so hopeful coming here today that with that 31-page ruling in Florida, we set the record straight, and that isn't going to change with a federal court based in Texas either. The First Amendment says you cannot tell someone else what speech they must carry.
Thank you. I was looking to see if you had any written testimony, but you didn't.
We do. I submitted that to each of you by email and your staffs yesterday afternoon. And I will, I didn't bring too many written copies, but I'm going to give you the one I have.
Thank you. I don't have it. Thank you, sir. Is there anything in this written testimony that you wish you had had time to cover that you did not?
Thank you, Senator. There's been some discussion today about common carrier. And I just wanted to clarify that common carriers are things like railroads, a century ago, oil and gas pipelines, some phone carriers, but not all, and the U.S. Postal Service. They're common carriers because they transport something, whether it's physical or ephemeral. They transport something from me to you, from you to you. And that transport is fundamentally different than a platform like social media who takes communication and broadcasts it more broadly to an audience of people. And that's what shows up in your feed, your Twitter feed, your Facebook feed, or the next YouTube up. So we haven't any common carriers yet that are anywhere close to this profile. And in the opinion from the Florida federal judge, he said that social media is somewhere in between a completely independent newspaper like the Austin American Statesman, where all the content is curated, and a common carrier like a telephone company that merely completes calls. So he did not find that common carrier could be hung on these social media platforms as part of his opinion. But that will certainly be discussed at the 11th Circuit. And as I indicated to you earlier, it's going to be covered there through the Florida law. It's going to be covered there in all three of President Trump's class action lawsuits. So there's plenty of conversation about common carrier without Texas adding itself to the fray.
Thank you. On page 5 of this written testimony that you provided, you say that Senate Bill 5 would make it extremely risky for social media platforms to remove or restrict sharing of objectionable content, including allowing Texans who post anti-Semitic content to sue social media platforms to have anti-Semitic content restored, and prevents YouTube from restricting user-posted videos with violent, hateful, or racist content that is inappropriate for children?
Thank you, Senator. All that content is protected by the First Amendment. So if Facebook, YouTube, or those took actions to restrict whether children could see it, because YouTube has a special restricted mode under which a household could switch on restricted mode, and videos that are categorized as inappropriate for children don't show in that house. And PragerU had sued YouTube over this in 2019, and the federal judge in California said that no, YouTube is a private enterprise. It is allowed to restrict that content. But under the First Amendment, if you're a common carrier, none of that can be restricted because the First Amendment would apply to that body. So I think that the key to understand here is that viewpoint-based hatred, viewpoint-based ethnic slurs, viewpoint-based pornography, medical disinformation and misinformation, election fraud, defunding of the police, all of that is viewpoint-based. So just be clear that anyone who articulates their First Amendment rights to state those things could sue if my member companies took actions to restrict the sharing of that. They hang a fact-check flag on it. And in those lawsuits themselves, entitled discovery process that Senator Hughes talked about, they also allow the plaintiff, if they win their case, to recover all the legal costs that are involved. That hassle, plus the Attorney General bringing a case, is likely to make all the companies turn down the dials on moderation of viewpoints that are protected by the First Amendment. Things will change. Things will change. You have some examples, Mr. Chairman, like, let's say, Rumble, Getter, Parler, and MeWe, all of which were social media platforms that pledged from the start to do a lot less content moderation. And they have struggled. They have struggled mightily to attract advertisers because advertisers do not want their ads. They don't want to pay to have their ads displayed next to hateful content, pornography, or other First Amendment protected speech. We call it awful but lawful speech.
Thank you. What impact would Senate Bill 5 have on your ability to block spam?
The blocking of spam is essential to make the platforms usable, both in terms of messages that come up in the feed, but also the direct messages that come through Twitter and Facebook. If Facebook, Twitter, and YouTube continue to block commercial spam, those entities would be able to say that their viewpoint has been suppressed and censored and be able to sue our companies for blocking spam from being delivered to your inboxes.
My goodness. On page 6 of your written testimony, you write, Senate Bill 5 violates conservative values of limited government and free markets. Could you please expand on that statement?
I represent there my lifetime in conservatism, but more importantly, the American Legislative Exchange Council, the leading state lawmaker group of conservatives. And Alec's position is laid out in there along with President Ronald Reagan's position, conservative positions that say that the government cannot force private TV stations, it cannot force newspapers, it cannot force social media platforms to carry content that they don't want to carry. So that violates the conservative principles that have been articulated by those two groups.
Thank you, sir. Thank you, Mr. Chairman.
Thank you, Senator Zaffer. Any members, other questions for Mr. Del Bianco? All right. Steve, thank you. Tell Pastor Holly and Pastor Joyce, hey for me.
I certainly will.
When you get back, and safe travels back to Dulles, okay?
Thank you, Senator.
All right.
Best to your wife.
Thank you, sir. Hooah. Thanks, Steve. Chair calls Scott McCullough, then followed by Tom Glass. With only one microphone, it's appropriate to just do one at a time, so I'll let each individual know who's on deck. So, Mr. McCullough, after you, it'll be Tom Glass, and then in the, not the on-deck circle, what is it, what's beyond the on-deck circle? I can't remember in the dugout, I guess, Gus Pena. So, all right. So with that, Mr. McCullough, if you would, please state your name, whom you represent, and you have 2 minutes.
Thank you, Mr. Chairman. My name is Scott McCullough. I'm here on behalf of Giga News, Inc. and Golden Frog. They're 2 internet-related companies, although Golden Frog is chartered in Switzerland. Its headquarters is in Texas. Giga News is a Texas corporation. We're here in favor of the bill. We prepared a 10-page memorandum in support of the bill, and I hope the committee members have already had a chance to receive it. We said there were attachments, and apparently the attachments didn't make it. We'll be happy to supply the attachments to anyone. Among those attachments is the Florida bill and the federal court decision on preliminary injunction, along with 2 articles by a constitutional law scholar named Eugene Volokh. He has been cited, by the way, by Justice Thomas a couple of times in his relevant opinions on these topics. I'd like to spend what little bit of time I have left, though, responding to some of the things I just heard. I don't know what bill the representative from NetChoice was talking about, but I don't think it's this one. The first thing that I think is important to understand is that all that Senate bill does is prohibit censorship. It does not prohibit any platform from taking a position on anything. They are still free to speak. They are still free to even flag information that they deem inappropriate or wrong or misinformation. All that it does is prohibit them from censoring viewpoint-based speech. And that is one of the most important things that distinguishes this bill. There are many things, but that is one of the most important things that distinguishes this bill from the Florida bill. If you read the Florida opinion, it is apparent that the court was really more concerned about several things in that bill that are not in this bill. Absolutely not in this bill.
Mr. Chairman.
Thank you, Mr. McCullough. Senator Hughes, you're recognized.
Ms. McCullough, you were talking about the matters that were flagged by the federal court on the Florida bill that are not in the bill before us today. Tell us about that.
Well, yes. For one, you don't exempt amusement parks like Disneyland, which, by the way, a form of common carrier. They're not just transport companies. Common carriers, it's an ancient principle, has to do more with the concepts of what we know as bailees in the law, bailments and bailees. It is the care of people or property. Restaurants are common carriers. There are many kinds of common carriers. But the court in Florida was really very, obviously, if you read the opinion, very much more concerned about 2 aspects of the bill, in addition to the exemption of Disney World. One was the special treatment of politician speech, and the other was the special treatment of what it called journalistic enterprises. The court had very specific problems with the inclusion and special treatment for that kind of content.
Now let's talk about the special treatment for politicians.
Yes.
As I understand the Florida bill, if you were to censor a politician, it was a more severe penalty than censoring just a regular individual. Did I read that correctly?
It was, yes. Florida chose to treat a certain kind of content, not viewpoint, content, in a special way. And that was viewed as problematic under the First Amendment by the Florida court.
Do you read anything in Senate Bill 5, the bill before us, that treats politicians differently from regular citizens?
Not unless they're expressing a viewpoint. If they are expressing a viewpoint, then it's protected by the bill.
Just like it is for everybody else?
Everybody else.
Go ahead, please.
The other problem with the Florida bill that is not in this bill is the fact that it required the platforms to take certain actions and indeed engage in certain types of speech themselves when dealing with a customer complaint or other types of content. Again, that is absent from this bill. And that is one of the things that's really a very distinguishing factor between SB 5 and the Florida bill. and when you get down to it, the First Amendment analysis here. Once again, if you read the opinion, it was clear that the Florida court was really concerned about the fact that the Florida bill actually made the platforms be speakers. And that is why it assigned strict scrutiny to it rather than the form of intermediate scrutiny that would be appropriate when you look at the cases that deal with neutral conduit hosting and things like cable must carry, or even going back to the telecommunications common carriage world. And we cite one case in our memo where courts had just came out and said, yes, of course the state can make a common carrier be a host, a neutral content host. Of course you can.
As we go, go ahead. Go ahead.
Well, I was just going to say once again, to the extent it's not made clear, these people are common carriers under the common law. They are. They meet every single criterion of common law, common carriage. Now, don't be confused by what many statutes may say about defining them for regulatory purposes. I'm talking about a common law, common carrier. And the criteria are really quite easy. They are endeavors that are affected with the public interest. They are ones that have a practice of holding out to indifferently serve in non-discriminatory terms and conditions. And these two social media platforms meet these criteria head up. It's certainly affected by the public interest. They're hugely important to society these days. But more importantly, you cannot go to any of these platforms today and say, I want to sign up to your service, but I want to negotiate this little piece of your terms and conditions. I want to alter the contract between me and you. They will say no. They will take all comers who sign their click-wrap forms of terms of service. They'll take anybody. They'll sign you up. They are, therefore, a common carrier under the common law.
And that's helpful. I want to ask you about that. Thank you for that distinction. And we were talking before with Delbianco, smart guy, and knows this law well. He was talking about common carriers as being in the transportation or transport industry, and going back to railroads back in the day, or bridges or ferries or things like that. But we did talk about how phone companies today are also in that category. These social media companies are transporting information, are they not?
They transport information, but they also process and store information.
Yes.
Now, if you're looking at this purely from a telecommunications law perspective, and specifically their definitions under the Communications Act and the way that the FCC has treated them, they are providers of an information service. They provide special processing services via telecommunications. Sometimes they provide the telecommunications, sometimes they do not. So if you're looking at this from an FCC perspective, and I practice FCC law, been doing it for 40 years. No, they are information service providers. But that does not mean they cannot also be common carriers.
You bet. Makes sense. Makes sense. We've also heard the argument, I think maybe in previous testimony, about how you can always go somewhere else if you don't like Facebook. Always go somewhere else. If you read Justice Thomas's concurring opinion in this Joseph R. Biden versus Knight First Amendment Institute. You probably saw that opinion. It's going to be in volume 590 of the U.S. reports. We don't have the page number yet because it's so fresh. It's hot off the presses, 2021. You're familiar with
I am.
Justice Thomas of the U.S. Supreme Court.
We discussed it in the memo.
I know you did. So let's talk about that a little bit. I want to quote part of it to you. So he's addressing this argument that you can always go somewhere else. You don't have to use these platforms if you don't want to. And so here's what Justice Thomas says about that. He says, much like with communications utilities, these concentrations, this market power, gives digital platforms enormous control over speech. It changes nothing that these platforms are not the sole means for distributing speech or information. A person always could choose to avoid the toll bridge or train and instead swim the Charles River or hike the Oregon Trail. But in assessing whether a company exercises substantial market power, what matters is whether the alternatives are comparable. Do you remember that language?
Yes, and Justice Thomas is addressing several different kinds of concepts, somewhat in an antitrust sense, but also just from a common sense. Now, in the antitrust perspective, your definition of social media platforms is not one that would be used in the antitrust concept. For example, it is much different than the one that was used in the FTC States case. For example, in that case, that market definition would have excluded companies like LinkedIn, even if they have the number of users that would cross your threshold. So your definition isn't an antitrust one.
That's right.
And so let's just get away from the antitrust idea here. Clearly, they do have very significant power here. Now, whether they are monopolies is a separate question from whether they have market power. Market power can be anything, once you understand what the market is, it can be anything north of 30%. But ultimately, what people worry about is whether one item is substitutable with another, whether it is reasonably substitutable. And here, the thing that you must understand, and by the way, I haven't seen your committee substitute yet, but I know that you're lowering the threshold some. Let's discuss that a little bit. I think the thing that distinguishes these particular ones that are at the numbers that you selected, that distinguishes them from all of the other potential alternatives, is the fact that they have crossed the threshold over what we call network effects. Network effects is an economics term, but it is also one that makes sense. It has to do with the number of people who are in the addressable market that are captured, not in the telecommunications network, but are in this little group of people who participate in some niche. And as these platforms get bigger, they have more pull to them. In an economic sense, the addition of an additional user is very much costless. The incremental cost of adding them is de minimis, but the social value of adding them is immense. And they get a certain kind of pull and therefore a competitive advantage.
That's right.
And that is why it makes sense to do the kind of line drawing that you do in your bill. Now, I know the Florida court had a problem with it, but I suspect that the reason that the court had the problem with that, with the fact that they had that $100 million threshold, was because it really wasn't pointed out to the court, look, we're just trying to get to the guys who are the problem here. It may be that somebody else can do the same thing, but they are not really substitutes. I can't talk to 60 million other people on these alternative networks.
That's right. Thank you for that. I was going to ask you about that, but thank you for you explained it better than I could have asked it. So thank you for that. I want to address another matter that came up a couple of times was Senator Zaffarini's excellent questions. She always has good questions and good answers, but there were specific concerns about violent, hateful stuff being removed, content, not viewpoint moderation. There was also at least the implication that if Senate Bill 5 were to pass, it would be no holds barred, no limitation on pornography or anything like that. So I want to direct you to a couple of things in the bill. On page 11 of the bill, you may not have it in front of you, but
I do.
There you go. Page 11 of the bill, section 143A.006, construction of chapter, starting on. Oh, I'm sorry. I'm reading from the committee substitute. This language has not changed. Do you have one? We're going to take you a copy of the substitute, Counselor, just a moment. We're going to, Counselor.
For me, it would be 005.
No, we're about to have the substitute in front of you. Will you turn to page 11 on, and thank you, Mr. Taylor, thank you, Ms. Corkle. Will you turn to page 11? On line 4, we're looking for section 143A.006, construction of chapter. You with me?
Yes.
You see where it says this chapter does not prohibit the social media platform from censoring expression that the social media platform is specifically authorized to censor by federal law, or from censoring unlawful expression. So they're not prohibited from censoring that which they're authorized to censor by federal law or unlawful expression. Did I read that right?
That's what it says.
Very good. And so let's talk about federal law. Section 230 of the Communications Decency Act, that's federal law, right?
Yes.
And so I'm going to read to you something from there, and you've got this memorized, but I want to make sure I get this right, because this is important. We wouldn't want folks to misunderstand or misrepresent what's in the bill. And it says, and I'm in section 230, section C2, and it says this. You've got this memorized. It says, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken. Yeah, you got 230 there. Go ahead. You know it already, but any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be, and this is important, obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected. Did I read that right?
You do.
So Senate Bill 5,
230C2A.
so Senate Bill 5 becomes law, incorporating federal law. We're not saying that everything that's constitutionally protected would be wide open on social media, are we? They'd still have the right to limit stuff in that laundry list. Obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. That's still going to be the law, isn't that right?
It is, and your bill would not prohibit that. I do want to point out a couple of things for those who will be saying, however, that Section 230 would still preempt much of your bill.
We're going to get to that in a moment. I just want to make clear that nothing in Senate Bill 5 would prevent companies from taking down pornography, offensive, hateful,
Not at
that
all.
sort of thing, based on the clear letter of federal law. Is that right?
That's correct.
Okay, so if anybody would say that they maybe misunderstood or didn't read the bill or something, right?
That's why I said at the beginning, I think they're reading a different bill here.
Okay, fair. And I mean anybody. I don't mean any particular witness. It's anybody who. It's a legitimate question to ask. And so now let's talk about Section 230. Again, Justice Thomas has written about this as well. He said a lot of folks are assuming 230. I'm paraphrasing because he's so much more articulate than me. But he says a lot of folks are assuming Section 230 prevents states from doing anything. He says you should read the whole thing. So talk about Section 230 and how it would affect Senate Bill 5. Please, go ahead.
Well, first of all, Section 230 isn't as sweeping as many say. It is not an absolute complete immunity statute. There's a couple of words in there that people often gloss over. And it's right there at the front. The social media action with regard to taking down content, it starts off by saying it has to be voluntary. They need to voluntarily take it down. Second, the action needs to be taken in good faith. And those two terms have real legal importance. For example, now, I'm not going to comment on all the recent events, but there are some people who are saying that many social media platforms have taken down information because they were perhaps contacted by some government official who cajoled them into or twisted their arm into removing somebody's information. In my viewpoint, I think, therefore, a good argument could be made that they're not immune because their action was not voluntary. Further, it has to be taken in good faith. And many of the stories that we have heard, and again, I'm not going to comment on the veracity of the stories, but if you just pay attention to what people are saying, I think a good case could be made that many of the takedown actions would probably be characterized as not in good faith.
Makes sense. Makes sense.
And that is a factual-based determination.
It is.
It's really important.
It is.
So anybody who's litigating this is going to be, just suing after the bill goes into effect. They're going to have to raise a facial challenge. And it's really hard to overcome fact-based issues like voluntary and good faith when you're raising a facial challenge. The harder part's going to be in an as-applied challenge.
I also want to ask you, because I've interrupted you a number of times, you were talking about because the Florida bill and the Florida ruling is so fresh and because it's come up a couple times, anything else we need to know about how the Florida bill and the Florida ruling inform what we're doing in Senate Bill 5?
Well, I just think it's really important to understand that they were treated, the platforms were treated as publishers and subjected to strict scrutiny under the Florida decision. And there's many problems with that decision. But I don't need to criticize it for purposes of dealing with this bill very much. There's one or two points. But it's a level of scrutiny that's going to be important here. This bill does not require anybody to speak. All it does is protect others' speech. And for that reason, I think it will ultimately come to play that when a district court looks at this, it will be given intermediate scrutiny, not strict scrutiny. And that is hugely important.
And when a district court in Texas looks at this, will it go to the 11th Circuit like that Florida case? Where will the Texas case go?
It'll go to the Fifth Circuit.
And I bet Texans would like to see the Fifth Circuit take a look at this, don't you think?
I think it would be useful to have the Fifth Circuit look at it, but I also think that Florida decision is going to have some issues when it gets to the 11th Circuit as well.
Thank you, Mr. McCullough. Pass the witness.
Members, other questions for Mr. McCullough? Right. Let me ask one if I may. Oh,
Yes,
Senator
sir.
Hughes, or I'm sorry, Senator Campbell?
It happens all the time.
I've tracked everything here, but I want to be more, I'm just an old soldier, so let me be a little more simple.
Well, I'm a Marine. Let me
Simpler
try
if I
to.
may. Because there certainly, things that concerned with those elements of the First Amendment and the like. When I'd asked about the Florida case, you've spent a lot of time explaining the Florida case. So I want to just be very basic here. Were the tenets of the Florida case that were granted injunctive relief that were a subset of the larger bill, were any of the elements that were injunctified, if that's the right word, are those elements in Texas law in this before us?
If you look at the very concluding part of the district court opinion, it enjoined two of the sections that the Florida bill implemented, 106072.
And what I'm getting at is that, please, you are clearly a person of great intellectual rigor. I don't need numbers. I just need, is what was injunctified in the Florida bill, is that duplicated in SB 5?
Some of the provisions that were enjoined in what was 5012041 of the Florida bill, there are some similar things in SB 5, some similar things. There was a censorship provision in the Florida bill.
Okay.
But the reason that the court gave for enjoining that portion of the Florida statute was all based on things that are not in this bill.
Okay. And it also, look, there's a more fundamental difference too.
Yes, sir.
Is that there's a district judge in Florida that rendered that decision, not a district judge in Texas, federal district judge that has not yet rendered such a decision. The appellate courts will be different, obviously, if the case gets to the Supreme Court. So even if there were things that were parallel, different judges will look at different things from a different perspective. So it doesn't mean you shouldn't approach the issue, but I'm just trying to be as rigorous as you and previous testimony. I'm just trying to make sure that I'm just an old soldier, that I'm understanding the specifics. So I very much appreciate it, Mr. McCullough. Thank you.
Thank you.
I understand. So, all right, members, other questions? I think Senator Campbell had a question. You
Yeah.
recognize Senator Campbell.
Thank you, Mr. Chairman. Thank you for your input. So there's private company, there's government, and then there is, can we look at these platforms as common carriers? Common law would apply, common carriers, so that what we're doing, because what we're doing is trying to expand our speech, because these platforms are suppressing speech. And so does that count? Are they treated different? Are we able to apply, for instance, this law to the platforms that are defined as common carrier? We can do that just as so that they can't infringe on free speech, like government can't infringe on free speech, versus just a private company that we can't make a law telling them what they can say and not say. Is my question clear?
I think I
Fall
understand.
into the middle there?
I think I understand what you're saying, and let me try to translate it
Can you
into.
try to make it clear?
First of all, let me emphasize that Texas has long recognized the concept of common law, common carriage.
That's-
In fact, if you look at many of the Texas statutes that deal with it, and I cited in my memo a very recent Texas Supreme Court case, even in the transportation code that deals with transportation common carriers, what it says is we'll treat them like common carriers under the common law. So Texas is a common law, common carrier state.
Okay.
Now, it's important to understand that this bill does not deem these platforms, it doesn't force them to be, it doesn't turn them into common carriers. It merely recognizes
Right.
that they already are. So we're not forcing anybody to be a common carrier here. We are just saying, you're a common carrier.
Right.
I'm gonna treat you like
Fine. Because of your what?
Because of-
the enterprise, you are a common carrier.
Because of the nature of your activities and the way you hold out to indifferently serve.
Right, but saying that, this is why we can have this bill.
Yes.
Because it applies to the common law, common carrier versus just private enterprise.
Yes.
Because the man before you, the witness before you, who is an advocate for many Amazon, Google, Yahoo, and others. So his testimony kept saying, don't pass it, hold up, delay, yada, yada. We are trying to get to a point because speech has been suppressed. We're trying to stop that. And I'm wanting to see, I know government cannot suppress free speech unless, for instance, it's porn, something that incites illegal activity, something that's unlawful. But I'm trying to see where these platforms fit in the middle, if you will, so that what we do can apply to them. And it sounds like we can because common carrier, common law, or however you said that. That's what I was trying to get to.
The law on common law, common carriers
Yes?
almost mandates the outcome in SB 5. Because when you are a common carrier, you are prohibited from engaging in certain types of discrimination. All that this bill really does is specify the type of discrimination. It creates a suspect classification, so
All
to
right.
speak.
I think you answered my question.
Now, but I do want to add one other thing. There's a separate part of the law dealing with like malls, other
I don't think
quasi-public
we need to
forums.
get to that.
And this bill can also be justified on that basis as
I'm just
well.
trying to find for what we are doing today. We are working on, we're looking at censorship of speech.
Yes.
And how this will now be a law on common law, common carrier. Thank you. Thank you, Mr. Chairman.
Members, other questions of Senator Nelson? You're recognized. Oh, I thought you were. Oh, okay. Okay. Members, other questions for Mr. McCullough? All right. Thank you for joining us today, McCullough. Thank you. You and Steve, very rigorous, deep conversation. So, hoo-ah. Thank you. Chair calls Tom Glass, and then Gus Pena is on deck, and then Kathy Turner is in the hole. So, with that, Mr. Glass, please state your name, whom you represent. You're recognized.
Yes, my name is Tom Glass. I represent myself today, and I'm in favor of the bill and the committee substitute. I am an active user of Facebook and other social media, and my speech has been suppressed by Facebook starting in 2020. I will not give you all the details because I don't have time. It's a long laundry list and a lot of different, but I'll characterize what happened was that not only did they deny me due process when they violated my rights, they also didn't even tell me why I was being punished. And of course, you can't get through to them, as you recognized earlier, Senator Birdwell. Worse, because I'm the admin of multiple groups, they threatened my groups, and it actually took action against my groups, and unless I became a trustee in their gulag and did their censorship for them. So we've got a problem here, guys, and this bill is well crafted, in my opinion, to fix the problem, and I very much appreciate it, and all the good work, the thinking through the complexities of it. Second thing I want to say is this. On one occasion, they did actually give me a reason why they were suppressing my speech, and they were very proud of their reason. Their reason is that they are a global company, and they have the same policies all over the globe. which means to me, what I translate, boom, 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 oh, their speech policies are designed so they can survive in communist China, and they're going to apply the communist Chinese suppression of speech to me so they can do business in China. Not acceptable. Not acceptable. So if President Trump has said he thinks they are state actors. Well, I don't know if they're a state actor for the United States government, but I think they are state actors for the Chinese communists, right? When they're suppressing my speech on a whole bunch of different reasons, including stuff about, their virus. One improvement. Oh, where's my I'm already out. Okay.
Senator Hughes,
Senator
Hughes, you're recognized.
Thank you, Mr. Chairman. Ms. Glass, what were you going to suggest as far as?
The improvement
Thank you. But what do you want to say?
Thank you. I love the fact that we're talking about viewpoint discrimination, but one of the things that they talk about all the time is, and you heard the representative here that was for Facebook say it, is they think that they are the official de facto fact finders. They are the official fact finders. And of course, this talks about viewpoint, and they're going to, I predict that if I go in and talk about what that they're suppressing me, they'll say, well, you're saying something that's just not factually true according to us or our contractors who we do all this fact finding out to. I think it's very important that we put a statement in that includes that statements of fact are a substantial part of the concept of viewpoint discrimination. They don't get to decide what's true and what's not and then tell me that I can't say something that they think is untrue. So that's the big improvement.
Thank you.
Yes.
Members, other questions of Mr. Glass? All right. Thank you for joining us today, Tom. Thank you, sir. Chair calls Gus Pena on deck, Kathy Turner, and then in the hole, Servando Esparza. Gus, are you here? Gus Pena. Chair calls Gus Pena. All right. We'll put we'll keep Mr. Pena on the list if we may, Madam Clerk. Chair calls Kathy Turner.
Thank you.
Hold on, ma'am.
Up there. Thank you, dear.
Chair calls Kathy. Thank you for joining us today, Kathy. And then on deck is Servando, and then in the hole, Donald Garner. With that, Kathy, welcome, my constituent. Hua. Please state your name, whom you represent, and you have 2 minutes, ma'am.
I'm Kathy Turner, and I'm representing myself. I'm not an attorney, and I'm not an expert, but I just wanted the committee to hear today the example of how my speech was suppressed on Facebook. During the regular session, I posted on Facebook asking my friends and people of the public, if they felt like it, to please make a comment on House Bill 783. This was a bill that would prohibit the construction of wind farms in the Devil's River Preserve. Well, I looked a few hours. I've never had a post that people don't comment on, but usually it's just recipes, things like that. But anyway, a few hours later, I looked, there was nobody that had commented. So I went to my high school reunion group for my class, and I asked them, did you see my post? And every one of them responded, no, I didn't. And I said, could you please go out and see how you can see my post? And the only way they could was to go to my Facebook page and then do a specific search on House Bill 783. Now, I thought this was egregious that I was not being allowed to comment on on a public policy matter that was before the legislature, because I just wanted to use Facebook as a way to ask people to please get involved in the political process. Because all they did was basically deprioritize my post, I don't know that the remedies under this bill would help, but I just wanted you all to know that
Go ahead.
that
Finish your thought, Kathy, just very
That-
briefly, finish your thought.
Facebook actually took action against somebody bringing up a discussion of the deliberation of this body. Now, I think it was because I used the word wind turbines or wind farm, and that may get under the global thing that Mr. Glass talked about. But so I'm real tempted to do a Facebook post of a recipe with the word wind farm or wind turbine in the title.
Thank you, Kathy. Members' questions? Senator Hughes, questions for Kathy?
Thank you for your testimony and for sharing that with us. And the situation you described would be protected. If they do anything like that to deplatform or push you down or limit your post access, so that it would be addressed. And I just want to say, you have, I know over the years you testified many times when you were in direct service to the people of Texas as a state employee. And I know recently, let me back up, I know you and your husband gave remarkable selfless service to the people of Texas and served in so many ways. And also some of your work has saved lives. I want to say this, I'm glad now that as you've left official state service, you can be here and express your views more, and we're so glad you're involved in this process.
Well, thank you for the opportunity to address you today.
Let me see.
Members, any other questions for Kathy?
Ma'am, not a
Senator Campbell, you're recognized.
Thank you, Mr. Chairman. Not a question, just a comment. Thank you for your work regarding the wind turbines in Devils River Conservancy.
And thank you for your bill on that regard.
Thank you. All right. Thank you, ma'am.
All right. Members, any other questions? All right. Thank you, Kathy. Safe travel back to McGregor. Thank you, ma'am. Chair calls Servando Esparza, and then on deck, Donald Garner, and then in the hole, James Hines. And members, we just recently had Samantha Fillmore is registered as a resource witness from the Heartland Institute. Now, we'll get to her. She registered last, but I want to make sure that folks know that we do have an individual registered as a resource witness still to come. So with that, Mr. Esparza, please state your name, whom you represent. You have 2 minutes, sir.
Thank you, sir. Chairman Hughes and members of the committee, for the record, my name is Servando Esparza. I am the Executive Director for TechNet in the Southeast region. I'm testifying in opposition to SB 5. TechNet is a national bipartisan network of tech companies that promote the growth of the innovation economy nationwide. SB 5 creates an incentive for companies to not remove objectionable content in order to avoid the lawsuit. So I want to make sure that you guys heard that piece, because I know it was asked a bit ago about what stops these social media platforms from removing content, and Chairman Hughes read Section 230. What stops that is the lawsuits. That is going to freeze up the ability for companies to then remove that, to then avoid being sued. So that is a key component. And some of that content is pretty harmful. I want to make sure that, Holocaust denial content, Nazi propaganda like Senator Zaffarini asked about earlier, that type of content is likely to stay on because the companies want to avoid being sued. So I want to make sure that is pretty clear. On the Florida bill that has been part of the major conversation here, I disagree with the speaker who spoke about the 2 provisions for the reasons for the decision. I know he mentioned the theme park one, which is not extremely correct. It was a component of it, but I think the judge took issue with the fact that there was, and I'll read from the actual decision. We should have provided copies to you guys on it, but the fact that they're singling out from page 18 of the decision, the concentration of market power among large social media providers does not change the governing First Amendment principles. As a reminder, they struck the decision was enjoined, or the case was enjoined due to First Amendment issues on both immediate and strict scrutiny, which NetChoice is the expert on that. But one of the other pieces is on the main principle about the Florida decision, it's also the fact that the what they say on page 21 of the decision is reining in the ideology of the large social media providers is precisely the kind of state action that was held unconstitutional. In this case, they named 3 different cases, the Tornillo, Hurley, and the PG and E case. What they talk about there is essentially that the state is then limiting a social media platform, an actor, from removing content on there. And the reason why it's important and why I'm tying the first piece about the hateful content that might be able to stay on there is social media companies by nature have moderated content because they want to ensure that people go to these websites, that it's family friendly, that it's workplace friendly. If they are not that, I'm sure the state would say, hey, you can't check some of these, social media websites on your state computer, or and some of that hateful speech, additionally, is stuff that you guys see about yourselves. Your public figures. Some of that content may not necessarily fit the definition of 230, but it's something that you want to remove on there. The social media platforms would be prohibited from removing some of that content without the threat of being sued.
All right, Senator Lucio, I know you have questions. You're recognized.
Thank you, Mr. Chairman. Mr. Esparza, thank you for your testimony. I want to ask you first a couple of questions. The Chairman Hughes said that we are protecting quote unquote viewpoint speech, which would include political and religious speech. Do you believe viewpoint speech would also include protecting hate speech?
Yes, I believe that some of the hate speech, some racist content, because someone can say, I believe in that viewpoint and I'm allowed to say it and I'm allowed to put it on this website, and I'm going to sue a social media platform for removing some of that content. That's what Senate Bill 5 would do for that individual. So some of the hate speech that you're talking about, they would be able to sue if that was removed.
Unfortunately.
Absolutely.
And I don't think that, knowing the senators I do and the presiding officer here as I do, and everyone else as I do, intend that to be the case, but unfortunately it would. Number 2, would you believe federal law itself is enough to protect against hate speech?
That federal law could prevent...
Is that enough to protect against hate speech?
Like an individual saying it out loud? Like saying it out loud, and if the federal government couldn't stop someone from saying something awful, I think there's limits to that, right? It's like the example that folks say about yelling fire in a theater.
It's going like that, which means we could supersede federal law, quite frankly. The states can, correct?
Supersede federal law.
And then, make them stronger. We cannot make them...
Oh, you can build off of a federal law. Yes, you can build off of...
Weaker, but we can make a stronger law.
In this case, on Section 230, where we're talking about a lot of this, the Section 230 is specific on what the state can do, and it can't do anything outside of the scope of, there's limitations there. So it depends. I guess my answer is it depends.
Okay. Well, I'm sure we'll have another opportunity to ask the framers of this legislation that question as well, and to share with us the research and the findings they had along those lines. That would be something we must do. Obviously, we want to do the right thing. Thank you very much for your testimony.
Members, other questions for Mr. Esparza? All right. Thank you for joining us today, Servando. Thank you, sir. Chair calls Don Garner, and then on deck, James Hines, and then in the hole, Alex Mead. So with that, Mr. Garner, please state your name, whom you represent. You have 2 minutes, sir.
Mr. Chairman and members, appreciate the opportunity to testify before you. My name is Don Garner. I'm Executive Director of Texas Faith and Freedom Coalition, whose mission is to give people of faith a voice in government. Toward that end, I have the privilege of speaking in support of bills like Senate Bill 5. Faith and Freedom Coalition has a membership of over 2.5 million nationally and over 125,000 here in Texas. In the most recent election cycle, Faith and Freedom Coalition distributed voter guides through volunteer canvassers to 5.9 million voters, with over 300,000 of those being distributed here in Texas, right around 310,000, in fact. We consider the freedom of speech enshrined in the First Amendment to be foundational to the freedoms we enjoy. Faith and Freedom Coalition is gravely concerned over the epidemic of attacks on freedom of speech in American culture in recent months. Now, I'll be clear to say we've heard some very qualified attorneys. I'm going to speak to some of the aspects of the bill, but at a very high level, of course. We strongly agree with the premise that Facebook, Google, and Twitter serve as common carriers. They hold a virtual monopoly on social media. I think probably almost anyone in America would agree with that. We also agree with the clarifying distinction between moderating expression based on content versus viewpoint. We also support the remedy provided in SB 5 to those who have been censored based on viewpoint. As Justice Louis Brandeis said in a famous quote, "If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence." We've all seen an escalation of the frontal assault on public discourse, especially in the past year or so. We need more speech, not less. SB 5 is a well-reasoned attempt to address the censorship occurring in social media, and I encourage you to vote for passage of Senate Bill 5.
Members, questions? Senator Hughes, you're recognized.
Mr. Chairman, thank you. Mr. Garner, thanks for your testimony. I'm somewhat familiar with the work of Faith and Freedom Coalition. You talked about giving people of faith a voice, and let's talk about that a little bit more. Is your group limited to people of a certain faith or a certain denomination or sect?
No, it's not.
Tell us about that.
Well,
some of your events, I know I've seen Catholics, evangelicals, Jewish people. Is that
absolutely, yeah, it would include all of the above.
And so those people would have different views on matters religious and even political, I would think.
Of course.
And is it your group's position that all of that speech, all those viewpoints should be protected, whether we agree with them or not?
That's exactly right. It's certainly not by accident that our founders in the First Amendment established freedom of speech and freedom of religion, and naturally giving people of faith a voice in government. Any attack on freedom of speech we view as a direct attack on freedom of religion at the very same time. It's a big issue.
Thank you, Mr. Garner.
Are you through, Senator?
Pass the witness.
Chair recognizes Senator Lucio.
Thank you. Now, I certainly agree with that. Ever since I can remember back in grade school, we studied freedom of speech, the Bill of Rights, and freedom of speech, the Constitution, everything in it that afforded us liberties and rights in the pursuit of happiness. I want to ask you, though, shouldn't we be crafting legislation to make sure we uphold that, but in the same content, ensure that we don't also protect hate speech? Because hate speech can obviously lead to destruction of our society. Do you agree with me on that?
I think that would be something probably that I couldn't just give a blanket agreement to, simply because I do have concerns, frankly, from the position of people of faith as to where our culture is heading in what they define as hate speech. It seems very possible, and I think perhaps even likely, based on what we're seeing happen in other cultures, hate speech, including themes that would be commonly preached in pulpits across our country.
But you in no way would support any effort in any piece of legislation that comes through these chambers that would protect hate speech, is what I'm asking.
No.
Thank you.
Okay. Members, any other questions of Mr. Garner? All right. Thank you, Don, for joining us today. Thank you, sir.
Thank you.
Thank you. Chair calls James Hind, and then on deck, Alex Mead. Has Mr. Pena joined us yet? Gus, are you in the room? Please raise your hand. Okay. And then in the hole will be Samantha Fillmore as our resource witness, Madam Clerk. So with that, Mr. Hines, you're recognized. Please state your name, whom you represent. You have 2 minutes, sir.
Thank you, Mr. Chairman. My name is James Hines. I am the Southern Region Director for the Internet Association. The Internet Association represents 41 of the leading Internet companies, and I'm here in opposition to SB 5. With respect to the initial town square comment, I just want to point out that just because social media sites are wildly popular and may have some concentration of market power, that does not mean that the fundamental principles of the Constitution do not apply. So with that, the First Amendment would apply in a challenge of SB 5, and there are 3 fatal flaws with respect to the First Amendment. The first is the bill's attempt to balance interests between conservative viewpoint expressions and liberal viewpoint expressions. We know this from the comments made by Governor Abbott recently and previous comments made by Senator Hughes this year and the last time that this bill was brought in 2019. And a court will find that there's not a compelling state interest in the balancing of those particular interests. The second fatal flaws with respect to the size limitations that are in the bill. The arbitrary number of 50 million users that is set in the bill discriminates against those who have 49 million users or less, talking about social media websites who are under the threshold, who are exempt from the bill. So that will raise an equal protection analysis, which will bring about an unconstitutional finding. The third particular provision under First Amendment that will be looked at will be the ISP exemption. So while we don't have a Disney exemption here, we do have exemptions for companies like AT&T, who owns Warner Media, Verizon, who owns Verizon Media, and Comcast, who owns NBC Universal, companies that may be subject because of the social platforms that they have. And so we think that strict scrutiny will apply and that the bill will be found unconstitutional because of these errors. And lastly, I want to speak with respect to the enforcement provisions. We believe that because there are no caps on monetary damages, that there's a private right of action that's created that will have hundreds of thousands of lawsuits in the courts.
Members, questions for Mr. Hines? Senator Zaffirini, you're recognized.
Thank you, Mr. Chairman. Sir, have you had an opportunity to read the committee substitute?
I've looked at the committee substitute this morning,
You did?
yes.
Do you have it with you?
Yes, I do.
You don't? Well, on the last page of it, it says, a person who was a user, as defined by this section, is added by this act before the effective date of this act. Before the effective date of this act, I repeat, may bring an action under such and such a section as added by this act to remedy censorship of the user's ability to publish or receive expression that occurred before the effective date of this act, if the censorship continues after this act takes effect and violates this code as added by this act. What would be the impact of Senate Bill 5 if this provision were included on your industry?
So we have over 12 million social media users in Texas, and if you just take a fraction of that, 5%, I think we have the potential for hundreds of thousands of lawsuits that will clog up our particular courts. And this provision that speaks to acts that occur before and after the effective date, it's just kind of staggering to imagine, what the burden we will have in our court system. But yeah, I think this will have a negative effect with respect to access to the courts because we will have so many of these users possibly in court.
Is your interpretation of this language is that it would authorize retroactive lawsuits?
Yes, that is my interpretation.
Thank you, sir. Thank you, Mr. Chairman.
Thank you, Senator Zaffirini. Members, any other questions of Mr. Hines? All right. Thank you for joining us today. Thank you, James. Chair calls Alex Mead, and then on deck, Samantha Fillmore, and then in the hole would be Gus Pena. Gus, if you're here with that. Oh, okay. All right, there we go. You still have Don Garner still on. He just testified a moment ago. So, All right. With that, Mr. Mead, please state your name, whom you represent, and you have 2 minutes, and you're recognized.
Yes, sir. Thank you, Mr. Chairman, members. Alex Mead for myself against the bill. I'll first say I listened to Ms. Turner's testimony with great interest, and after she finished, I went and looked up her post on Facebook. I searched for it, was able to find it there. I then went to her timeline and found it separately on her timeline without searching. I didn't see any misinformation flags on it, and I thought it was a perfectly fine post. What I will say is that I post a fair amount on Facebook myself. I'm relatively liberal. I've seen my posts get wildly different amounts of engagement for reasons that I don't know. And I also know that I've seen my friends' posts perhaps 2 or 3 days after they were posted, and maybe I'll see someone's beach vacation right at the top of my timeline right when it was posted. My point is, I don't really see the sort of political viewpoint-motivated censorship that has been alluded to in this hearing. What I do see is that social media websites will perhaps lessen the distribution of or flag or sometimes remove, in extreme cases, posts that don't represent the kind of community they want to foster on the site. I've seen this, for instance, with posts with some of the misinformation that fueled the attack on our democracy that we saw on January 6th. I know not all of you agree with that characterization, but I hope that at least all of you would agree that hate speech, racism, things like that are something that if a website doesn't want to use its servers and its bandwidth to publicize, it shouldn't have to. I mean, after the England versus Italy soccer game or football game for those outside this country, just this past weekend, we've seen references to some of the players' ethnicity and trying to imply that they're of lesser ability because of that. I mean, if someone says so-and-so shouldn't have taken the penalty kick because they're black, is that content or is it a viewpoint? And I'm concerned that a bill like this would prevent communities from being able to regulate their content and make sure they're fostering the kind of community they want. Thank you.
Members, questions for Mr. Mead? All right. Thank you for joining us today, Alex. Thank you, sir.
Thank you, Mr. Chairman.
Thank you. Chair calls Samantha Fillmore. Samantha, if you would please join us. Please state your name, whom you represent, and you'll have 2 minutes. Members, Samantha's registered as a resource witness, and with that, you're recognized.
Hello. Hi, Chairman Hughes and members of the committee. Thank you for having me here today and holding this hearing. My name is Samantha Fillmore. I am the State Government Relations Manager for the Heartland Institute. This year, since I work on state politics, we have seen 70 pieces of legislation in 30 states, all attempting to challenge big tech in some way. And I had the pleasure of speaking before all of you back in the spring. It's okay if you don't recall. I know you're all very busy. But the sheer volume of these bills indicates that many Americans in states, including Texas, and the fact that we're even talking about this in a special session, indicates that this is an issue that a lot of Americans think of. We see that we might be entering into a potentially dangerous time for free speech in our country. We've heard opponents of this legislation claim that censorship is appropriate because market forces have allowed these titans to gain the power and amass the quantity that they have. And to that, I would submit to you that this is not the product of a healthy free market, but rather the product of a corrupted one because of Section 230, as we've discussed, and the liabilities that it gives these big tech platforms. And that's why we're here discussing Senate Bill 5, which is attempting to address this through what I would like to point out, a very important state-based exemption in Section 230. It is subsection E, subparagraph 3 in Section 230 that says nothing in Section 230 shall be construed to prevent any state from enforcing any state law consistent with Section 230. And as we've established earlier in this hearing, Senate Bill 5 is in fact very much congruent with Section 230. Moreover, I want to address to you that private corporations have no more of a right than the government to suppress free speech. I'm a proud Texan and Texas X, and I can confidently say that Texans would never stand for a neighbor breaking into their house as much as they wouldn't stand for a rogue policeman. In this example, that is both a private entity and a government entity, and both are not okay. And the same goes for the First Amendment and free speech. Our First Amendment right to free speech does not exist because the government gave it to us, but because it is inalienable, and that is what this bill is intended to protect. So thank you. If you guys have any questions.
Members, questions for Samantha? Senator Hughes, you're recognized.
Hey, Mr. Chairman, thank you for your work. Thanks for being here. And to the point you were making at the end, as you know, hasn't Justice Thomas written about that, the fact that the government, for example, in writing Section 230, can't just delegate to these companies censorship that it could not do itself. Isn't that right?
That is right, and that is why that exemption exists. It is essentially begging for states to create legislation such as this that would allow a question and a check on big tech. So yes, without fully repealing Section 230, which, as we've all established, Section 230 is good for a reason. Again, lewd, lascivious, pornographic, everything we hear.
That's right.
Yes.
Thank you very much. Thanks, Mr. Chairman.
Thank you for
Members,
having
other
me.
questions? All right.
Thank you, members of the committee.
Thank you for joining us today, Samantha. Last call, Gus Pena. Gus, are you with us? All right.
Could I ask you a question? Is Mr. Pena in?
Say again?
Is he here?
That's my third time to call for him. He's not answered the bell.
Could I ask you, if I may, at this point, based on the fact that Senator Campbell, Chairwoman Campbell knows he is a respected veteran, and I'm interested in his position. How did he register?
He registered for the bill.
Okay.
So we'll put Mr. Pena's position as registered for the bill as part of the record, but we'll annotate him as not providing public testimony. Members, that concludes public testimony of what I have registered. Is there anyone else wishing to provide public testimony on, for, or against Senate Bill 5? Hearing and seeing none, public testimony is closed. What are your directions, Mr. Chairman? Okay.
Do you recognize me for a motion, Mr. Chairman?
Senator Hughes, you're recognized for a motion.
Thank you, Mr. Chairman. Members, I move that Committee Substitute Senate Bill 5 be reported favorably to the full Senate with a recommendation that it do pass. Oh, you know what? Let's adopt the substitute first. I previously laid out a substitute, and I move adoption of the committee substitute. Thank you, Ms. Smith.
Members, Senator Hughes moves adoption of the committee substitute. Is there objection? Hearing and seeing none, it is so ordered. Committee substitute is adopted. Senator Lucio.
I just want to tell Chairman Hughes, who I respect and care a lot for, my neighbor on the floor, that I have a little teensy-weensy amendment that if it passes, I'll vote for the bill.
Well, thank you, Mr. Chairman. And so you mean when we get to the floor?
Yes.
Oh, no, thank you very much. Look, thank you. Please let me look
Sure.
at it. I appreciate that.
Absolutely.
Thank you. You know, Senator Lucio would never offer an amendment on one of my bills like that. I know that. That would never happen. His amendment strikes everything below the enacting clause.
Okay. All right, members, you've the committee substitute is before us. Did you wish to make the motion?
I'd like to make a motion, Mr. Chairman. Thank you. I'll make the proper motion, and thank you again. I move that committee substitute to Senate Bill 5 be reported favorably to the full Senate with a recommendation to do pass and be printed.
Members, you've heard the motion. Madam Clerk, please call the roll.
Campbell. Hall. Lucio.
Nay at this time.
Nelson. Powell. Schwartner. Zaffarini.
No?
Birdwell.
Aye.
Hughes.
Aye.
6-2. There being 6 ayes and 2 nays, committee substitute Senate Bill 5 will be reported favorably to the full Senate. Mr. Chairman, I'm going to give you the gavel back.
Thank you, Chairman.
Thank you, sir.